All right, on to the legal ramifications, the legal part of dental radiography. Starting with the question, who owns the dental images? The dentist owns the dental images. A patient has a right to a copy of these images. And I do want you to think about images when they were actual dental films, but even as digital images, the ownership of the digital image is the dentist. The patient pays, they're paying, so sometimes they think they own the image, but they don't. They're not paying for the images themselves. They're paying for the diagnosis and the interpretation of the images, not for the images themselves. So laws exist that govern the use of ionizing radiation, govern who must be informed of and comply with these regulations, and of course, in regards to negligent care. And we'll talk about some of those. Federal and state regulations govern the use of dental x-ray equipment. As you know, the manufacturing is regulated by federal regulation once it's in your office. Once the unit is installed, the dental x-ray unit is installed, then it is governed by state regulations. But here we're talking about who can take dental images, training, and certification. The major federal law that covers dental radiography is the Consumer Patient Radiation Health and Safety Act. This is a federal law that requires persons who take dental images to be properly trained and certified. It outlines the requirements for the safe use of dental x-ray equipment, and it establishes guidelines for the proper maintenance of x-ray equipment. So that's all bound in the Federal Consumer Patient Radiation Health and Safety Act. Each state deals with dental radiography differently. Many states require x-ray machines to be registered, including Michigan. Most states require dental x-ray equipment to be inspected every 5 years. In Michigan, and state laws also regulate who's qualified to expose images. So that varies from state to state. In Michigan, the dentist, the registered dental hygienist, or the registered dental assistant are not required to obtain additional certification to expose images because they have all successfully completed a Commission on Dental Accreditation radiography course. On-the-job trained assistants must complete a course determined to be substantially equivalent to a CODA course, a Commission on Dental Accreditation course. So we're going to talk about some legal issues now and start with risk management. Risk management are the policies and procedures that should be followed to reduce the chances a patient will file a legal action against you, the dental radiography, or the supervising dentist. And so offices, clinics have policies designed to reduce the likelihood of a malpractice lawsuit. We want to reduce the risk of that. You, as dental radiographer, must be careful never to say anything negative about how the x-ray equipment is working or what's going on with it. Statements made by anyone at the time of an alleged negligent act are admissible as evidence in court. Self-determination. Self-determination is the legal right to make choices about the care you receive. This includes the opportunity to consent to treatment or the opportunity to refuse treatment. So human beings seeking health care have the legal right to make choices about the care they receive, and that's self-determination. It's the dentist's responsibility to discuss the need for images and certainly other treatment procedures with the patient. The process of informing the patient about the particulars of a treatment, and dental radiography is a treatment, is disclosure. So The process of informing the patient about a treatment is disclosure. With disclosure, we want to make sure the patient has received enough information to make an informed choice. They have the information provided in lay terms, not oversimplified, but in lay terms, and of course given the opportunity to ask questions. Have I answered all of your questions? With informed consent is the consent given by the patient following complete disclosure. To obtain informed consent, we want to explain the purpose of the procedure and its benefits, who is going to be responsible for the procedure, any risks associated with either having the procedure done or risks with not having it done, right? And alternatives to the procedure. Certainly for dental imaging, we get verbal consent, verbal informed consent. Liability. Liability means legal accountability. The dentist is legally accountable. The dentist is liable to supervise the performance of his or her dental staff. Dental staff, you are liable for your own actions, and you and I may both be sued for the action of the dental auxiliary. So your actions may cause both you and I to be sued. Sued for what? Couple definitions here. Negligence. When the diagnosis made or the treatment delivered falls below the standard of care. That is negligent care. So falling below the standard of care. Negligence can be the result of action or no action of the dental profession. So perhaps the treatment, the action, was below the standard of care, or the fact that a treatment wasn't done or completed. That lack of action can also be considered negligence. Standard of care, it's defined as the quality of care provided by practitioners in a similar locality under the same or similar conditions. You might think about it this way. So what the average dental hygienist in Grand Rapids would do on an average day, right? The standard of care. That varies from locality to locality. So what a dentist or dental hygienist might do as standard of care in Michigan may be different from what they do in Texas. So locality has something to do with it as well. Malpractice is the result of negligence. It is the result from the dental practitioner being negligent in the delivery of care. We also consider the statute of limitations, the time period during which a patient may bring a malpractice action against the dentist or against the dental auxiliary. Individual states govern the statute of limitations. The statute of limitations, that time period during which a patient may bring a malpractice action against you or your office, the time period begins when the condition is discovered. Right? Not when it happened, but when it's discovered. And it may not be discovered until a patient seeks care from another dental professional that they begin to learn that previous treatment may have been negligent. So it's the responsibility of the dentist to review and report all information presented on dental images. In Michigan, the law states that a claim for medical malpractice must be filed within 2 years of the negligent act, or if the injury was not discovered until later, and that often happens, within 6 months of discovery, but in no case longer than 6 years after the date of the negligent act. Documentation is key in legal accountability. We get our informed consent from our patients verbally. You will want to note the number and type of images exposed, why were the images taken, and a report on the information obtained from the interpretation of images. For example, you've exposed 4 bite wing x-rays. So 4 bite wing x-rays taken for caries detection, no caries noted. Deals with the number and type of images exposed, why they were taken, and a report on what was found. A little bit about digital images in the law. Originally, it was thought that because an original digital image could be enhanced, it was questionable whether they could be used as evidence in lawsuits. That's initially, but digital images and digital diagnostic imaging systems have integrity. Right? They have a time and a date stamp for a digital record each time something is exposed and also modified. Our software systems, EagleSoft for example, only allows for the change of contrast or coloration. It does not allow an individual to place pathology where none exists. You can't put decay on an image where it didn't exist before, or you can't put periodontal disease or bone loss where it didn't exist before. So the software systems don't allow the modification to place pathology where none exists. It is conceivable that a provider could use a photo program to alter an image to show pathology, but that's an awful lot of work for fraud. So unlikely to be done. Confidentiality, privacy, all information in the patient record is considered confidential, and confidentiality prohibits transfer of information to non-privileged persons. Who are the non-privileged persons? Any individual not directly involved in the treatment of that patient is non-privileged. Certainly other patients, family members not listed on a patient's HIPAA form, co-workers not directly involved in the treatment of the patient is non-privileged. And state confidentiality laws protect information in the patient record, including dental images. So again, a little bit on dental image ownership and retention. Dental images are the property of the dentist, even though the patient is paid for them. The patient is paying for interpretation and diagnosis. Patients do have the right of reasonable access to their records, images and digital records. We don't, again, I want you to think about this in a paper format or a film format. We wouldn't give or send original images to a patient. Dental records, dental images are retained by the dentist, and the patient can receive a copy of them. Patients who refuse dental images. It's a situation that happens and must be carefully considered by the dentist. Legally, a patient cannot consent to negligent care. Even you recommend radiographs for your patient. Your patient says, no, I don't want them. You explain the benefits and the risks. No, they don't want them. You say, fine, you have to sign this paper that says, I've refused x-rays. In a court of law, legally, the patient cannot consent to negligent care. Providing treatment without current image of the problem is negligent care. That's it. Thanks for listening. I'm going to see you next week. We're going to have lots of radiographic interpretation in week 6 and 7. Let me know if you have any questions, and thanks for listening. Bye-bye.